Hello and welcome to our presentation on Introduction to Law. This is Task A, Arbitration, by Ben Hindman, Nathan Dewey, Rachel Donoghue and Beth Pritchard. Welcome to our presentation on Task A, Arbitration. In this presentation we will outline several points and discuss different topics, such as what is arbitration, which will be covered by myself, the processes of arbitration, which will be covered by Nathan, benefits of arbitration and disbenefits of arbitration, which will be covered by Rachel, and how arbitration compares to litigation, which will be covered by Beth. What is arbitration? As per the Arbitration Act of 1996, which states, arbitration is to settle disputes by an independent party without delay. It is up to the parties to choose how they resolve their disputes. Facts. Here are a few facts about arbitration. So the first one, the New York Convention, includes 157 parties, which they all recognise and enforce arbitration awards. So, for example, if it's been awarded in one country and you move to another one and you fail to meet it, then it can still be enforced so long as that country is within the 157 parties. The second point, the International Chamber of Commerce has reported a total of 966 referral requests which have been filed in 2016. This is a record high. The third one is that many shipping companies choose London for their arbitration cases. This is for several reasons. The first one being that the UK keeps all cases out of public eye, so that if there's something in there that's private and you don't want people to know about, then they won't. The second one is that London has been the centre of shipping for many centuries, so this is something that appeals to many parties to hold arbitration cases in. The third and final one is that UK common law is well liked and is actually very well established, and many laws around the world are based off it. Therefore that's why London is chosen to hold many arbitration cases, and as the point above shows, a record high number of arbitration cases for 2016. So far the effect of Brexit hasn't been noticed with arbitration cases, but that's not to say that we won't see anything at all. Only time will tell. Example of arbitration cases. Here is a list of many cases that involve arbitration for shipping companies. I won't talk about all of them because there are quite a few here, but I'll go through a few for examples. For example, if there's a disagreement between the bill of lading between the shoreside and ship, and this can't be resolved, this may be something that will be taken to arbitration and hopefully will be resolved there with the correct outcome. Another is if one party has not been paid, for example, or failing to payment of the charter fee, then this as well can also go to arbitration and be settled there. All of these examples of arbitration, hopefully many of them don't actually occur and are settled there and then and don't have to go all the way through to arbitration.
Arbitration is split off into different schedules. So we've got the first schedule, second schedule, third schedule, fourth schedule and fifth schedule. With this, then I'll explain that a little bit later when we go through this. The first thing to understand is how do you finally get into arbitration. So this could be voluntary or mandatory. With most contractual disputes, then that means that it's mandatory to go through arbitration. So it's pretty simple. It means that you're contractually obliged that you need to go through the arbitration process and you can't go through any other legal process to resolve the situation. Between the two parties, then you'll agree what the arbitration will be. So with this, then it means that you choose what the rules are and what country and the rules that you have stated. So the most obvious one is to use the British rules, so the British law. This is because it is a very common law and most of the laws around the world are based off of UK law. The next one is, where will the arbitration take place? So the arbitration can take place in many different places. A very common one would be to use the London Arbitration Centre, but also there is New York and Singapore, which are big arbitration centres. Depending on where your business is and what you need to do and where you need to go, then you'll choose that as your arbitration hub. Okay. Choosing the arbitrators, so to choose the arbitrators there will be party A, which could be you, and party B. So party A chooses an arbitrator, party B chooses an arbitrator, and then the arbitrators from party A and party B choose an arbitrator of their will. The arbitrators that will be chosen will be maybe specific for that area so that they can use their knowledge and their best interest to resolve the situation. So if it's to do with marine pollution, then maybe there'll be a person who specialises within marine pollution to help resolve the situation. Then you need to submit your case. So submitting your case is what are the rules, what you will choose between the two parties to be able to decide how everything will run. You will submit your case, so you'll hand over all your evidence and what you need to hand over to be able to front your cause. This will take into consideration the type of documents, also the timings which you will be scheduled to, and then from this the arbitrators are in charge of the schedule, so that they are a third party and they are choosing what needs to happen and you need to show up at them certain times. Arbitration then happens and a decision is made. This decision is called the award. Within the award, then the award can be spoken out, so this is normally given in an opinions letter, or it can be confidential. This all depends on the rules that you set beforehand, before the arbitration started. Normally, the arbitration rules will state that it will come with an opinion letter so that both parties can understand where the arbitrators have come from to make their final decision. From this, then there will be a time frame put in for the parties to enforce the arbitration award. If this is not done, then it will need to be taken up with a higher up party. So it could be taken up with the UN or IMO to resolve this situation. Otherwise, the arbitration does not stand on a legal front as a resolution. Okay.
In most cases takes a lot less time than litigation. If the issue can be resolved quickly, then it can be a great benefit, and in some cases time is money, and there may be a hurry to settle the dispute. In most cases, the cost of arbitration is cheaper than litigation. Because the cost of an arbitrator is less than the cost of court, lawyers and the surrounding fees associated with court, a big saving in the costing comes from the more relaxed rules around submitting evidence. For example, if a witness is out of the country, then normally a statement can be given, whereas for court the witness would need to be present on the day, and that could be at the cost of the company to get them there. In cases that involve sensitive subjects or something that could be damaging to the company's reputation, then they may prefer to use arbitration over litigation, as it can be kept private and confidential and stop any information that they wouldn't want to become public being leaked. Arbitration provides flexibility. Unlike court, it can take place anywhere and fit around everyone's schedules involved, which is a lot more convenient for both parties. Usually the arbitrator is chosen by both parties, meaning they are not biased and will keep a level playing field, ensuring the final agreement is fair and no party is at a disadvantage. Unlike court, it's very hard to appeal a decision made during arbitration, and this can both be a benefit and a disbenefit depending on the circumstances. If the final decision has ruled unfairly in favour of one party, this may be a benefit to them, but also it can be a better option for some parties, as once the decision has been made, it's final and they no longer have to worry about it. Arbitration does not require many of the time-consuming and costly procedures that litigation does. For example, multiple hearings. This saves the parties both time and money. Due to stricter rules of evidence in court, arbitration allows more sources of evidence to be used than the courts would. This allows the arbitrator to take all of the information into account before making their decision, making it a better informed one. Disbenefits of arbitration. As I've mentioned before, the finality of arbitration can be both a benefit or a disbenefit depending on the circumstances. On the flip side, if the final decision is made and there's been a mistake leading to an unfair ruling in one party's favour, this may be a great disadvantage and no opportunity to correct it. When it comes to evidence, the fact that it has been simplified can be both a benefit and a disbenefit as well. Although having simplified the evidence can make it easier, but it can also put one party at a disadvantage. For example, when the other party have a witness who hasn't been able to attend the arbitration and has therefore submitted a statement, the other party will have no opportunity to cross-examine this witness. For similar-sized companies, arbitration can be the best option, as it is kept fair. It has been argued that between large companies and individuals, such as employees or a consumer, it can end up with an unfair result when it comes to arbitration. Although I said earlier that arbitration is a cheaper option than litigation, this isn't always the case. If a decision isn't reached quickly, and the cost of arbitration will continue to rise. But even if it is more expensive, there might still be other appealing qualities of arbitration which will make it a better option. Just as I said before about arbitration not always being cheaper, it's not always quicker as well. If the parties cannot come to a mutual agreement, then the issue will be unresolved and will continue until a decision can be reached. The decisions made at arbitration are normally final, which can be a good thing, but if one party feels that the decision made has been unfair, it can make it very difficult for them to appeal this decision. With no jury present, the final decision is very much reliant on the arbitrator and the parties involved coming to a mutual agreement. This can lead to an unfair agreement when there is only one person's opinion on what they think is the right decision, as the arbitrator is the person who will have the final say. As arbitration is a private process, the final decision is not accessible to the public, which, like I said before, for sensitive subjects, some individuals will prefer this, but it can also mean that there's a lack of transparency, which other people could argue that it leaves room for the final decision to be biased. To summarise, arbitration is a very useful process for resolving disputes. But when making decisions between arbitration and litigation, you must always weigh up the options as to what is going to be the better option for the case at hand.
There are 7 different ways that arbitration is compared to litigation. These 7 ways are public and private formality, the speed of process, cost of process, selection of the arbitrator or judge, the use of attorneys, the evidence allowed, and finally, the availability of the appeal. Public and private formality. The arbitration process is private, informal, and between the 2 parties only, when litigation is a formal process and is conducted in a public courtroom. The speed of process. Once an arbitrator is selected, the arbitration process can have the case heard immediately. However, in civil litigation, a case must wait until the court has had time to hear it. This could mean months or years. The cost of process. The arbitration process only has the arbitrator fees. This could vary in price when the litigation process has court costs and attorney fees. The selection of arbitrator or judge. The arbitrator is chosen by two parties in the arbitrating process. However, in the litigation process, the judge is appointed and the parties do not get a say in this. The use of attorneys. The arbitration process has attorneys representing them, but in civil litigation, attorneys spend their time gathering evidence and then represent the party. This makes the prices very high. Evidence allowed. The arbitrator controls what evidence is allowed in the arbitration process. However, in litigation, it requires full disclosure of evidence for both parties. Finally, availability of appeal. The arbitration process usually has no appeal option unless an appeal has been included in the clause. The litigation process has the option of an appeal. Okay. After looking at the findings discussed in this presentation, we have come to the conclusion that for maritime professionals, arbitration tends to be the better option when dealing with legal issues. This is because the advantages far outweigh the disadvantages. For example, the cost of arbitration is much less in most cases. The time that arbitration takes is much less than litigation, which is favourable in the shipping industry when time can cost money. Arbitration is final. Thank you for watching.